Oh, got
There's
it.
not even any mention of it at all. Should there just be at least like a vague mention, or?
I don't think so. It was just a pause. Yeah, I don't think so. I'm going to get us started. I call this meeting of the West Hollywood Rent Stabilization Commission to order. Please join me for the Pledge of Allegiance. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Trevor, may we have the roll call?
You may. Commissioner Kerpes.
Here.
Commissioner Maggio. Commissioner Martz.
Here.
Commissioner O'Keefe.
Here.
Oh, Commissioner Topchian.
Here.
Vice Chair Bergstein.
Present.
And Chair Charity.
Here. Thank you. Before we begin the meeting, we have an adjournment motion from Commissioner Bergstein.
Yes, thank you. I would like to request that we adjourn in memory of my mother, Ruth Ann Bergstein, who passed away on the 13th after a long journey with dementia, a particularly cruel disease. Because she was passing from dementia, I actually had the luxury of time of researching my mother a bit, because, you know, as a kid, we always knew mom's just busy. But if anyone's curious as to where my commitment to public service comes from, it's from the culture I was raised in. And I probably missed out on some of what Mom did, but this is what I was able to find out. So Ruth Ann Bergstein served on the Midland Hospital Women's Volunteer as the president, Midland Hospital Auxiliary president, Temple Bethel founder and teacher, Midland Coalition for Choice chairperson, Child and Family Services board of directors, American Heart Association chair, the New Democratic Coalition, the League of Women Voters, and was active in the Democratic Party at the local, state, and national levels. So we could adjourn in Ruth Ann Bergstein's memory. Thank you.
Thank you. We all definitely felt your loss, so thank you for sharing. Commissioners, anything else? Very well. We'll move on to item 4, approval of the agenda. Commissioners, having reviewed tonight's agenda, do you have a motion to approve or any amendments?
Motion to approve, Chair.
Second.
Thanks very much. All those in favor, please say aye.
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 Thank you very much. Moving on from item 4 to item 5, approval of the minutes of our last meeting, April 11th. Commissioners, having reviewed the minutes of our last meeting, do you have any amendments or motion to approve?
Motion to approve.
Thank you.
Second.
Thanks very much. All those in favor, please say aye.
Aye.
Very good. Moving on from item 5 to item 6, public comment. I don't have any public comment in front of me. Do we have any public comment this evening? No, very well. So moving on from item 5 to item 6, our manager's report, and we'll have that from our housing manager, Mr. Peter Noonan.
Good evening. At this time, I'm going to review the look-ahead schedule that you have in your folder. And looking ahead through May, June, and the first meeting in July, we do have appeals scheduled each of those meetings. There's double appeals on all meetings in May and June. July 11th does have one appeal. This is also the meeting that we typically rotate the chair and the vice chair. That's my report.
Thanks very much. Commissioners, do you have any questions or comment for staff? Very well. We'll move on from item 7 to item 8, commissioner comments. Do we have any commissioner comments this evening?
Just a reminder that I will be absent May 23rd.
Commissioners, any further comment? Nope. Very well. We'll move on from item, excuse me. Item 8 to item 9 are appeals. We'll start with Appeal 9A, that is D-4363, address 1314 North Hayworth Avenue, Unit 201. This appeal was filed by Robert Braun, the landlord. Is Robert Braun or a representative present? Very good, thank you. The tenant, D.D. Howard, or tenants representing the tenants, or is D.D. Howard present? Or, very good, thank you. At this time, we'll have a report from our staff attorney, Allison Regan.
Thank you. D.D. Howard applied for a rent reduction for various issues at the property, and the hearing examiner awarded a rent decrease for common area issues as well as for an individual unit issue regarding the heat. Robert Braun has appealed the decision generally in that he claims he was denied due process since he was not present at the hearing. His lawyer and resident manager were present but chose to leave the hearing when their request to continue the hearing was denied. He also appeals specific issues on the grounds that he has evidence to refute the tenant's evidence. Finally, he contends that the hearing examiner's award of rent decrease contradicts her findings. Staff recommends that the Commission affirm the hearing examiner's decision. The evidence in the record shows that the landlord is a corporation that was represented at the hearing by counsel and the current resident manager. At the hearing, they demanded that the hearing be postponed until Mr. Braun's preferred date. When their request was denied, they left the hearing. In addition, all of the witnesses cited by Mr. Braun in his appeal as having relevant evidence could have testified at the January 3rd hearing. Thank you.
Thank you very much. Commissioners, questions and comments for staff? Mr. Bergstein?
Ms. Regan, so this is kind of a first for me, this appeal. If I would understand this correctly, that because the owner and their representatives left without presenting any evidence, any testimony, there really is nothing they could bring tonight that would not be considered new evidence. They cannot bring any evidence, any testimony, anything to refute what the tenants have alleged because they did not do so at the hearings. Would that be correct?
That's correct.
So there isn't a whole lot that the owner would be able to bring up without being new evidence.
That's correct.
Thank you.
Commissioner Kirby.
I have a question. So one of the, it's my understanding that part of the appeal is an appeal of the hearing examiner's decision to proceed, right, without them present or without them remaining in the room. One of the questions I had then was, it states that the tenant never received notice, or I'm sorry, never agreed to the January 24th date or those other 3 dates that were mentioned in the initial, by the request by the landlord. Does the landlord states, signs by penalty of perjury that notice that this was agreed upon and testifies that it was agreed upon, but does the tenant, do they testify under oath that it wasn't agreed upon?
So the landlord did not say that. So in the landlord's rescheduling request, he acknowledges that for that particular request, he was unable to get in touch with the tenant, but he says that earlier they had agreed to this January date. So that would be an earlier date. And the tenant at the hearing, so the tenant would have been under oath at the hearing, said that she did not agree to that date.
Okay. I think that's all I had.
Commissioners, any further comment or question? Very good. We'll move on to the parties. This appeal was filed by Robert Braun. So here are basically the rules of engagement. Each side has 5 minutes to speak to us this evening. As the appealing party, Mr. Braun, you can divide your time, meaning you can inform our secretary how much time you'd like to speak in the beginning, and then we'll hear 5 minutes uninterrupted from the defending party, and then you can rebut with your remaining time in that 5-minute block. So when you're ready, you can please step to the podium, inform the secretary of your time blocks, and understand that we can't take any new evidence.
Right, definitely.
Thank you.
Sure. Probably about 3 minutes right now. Yes, okay. So am I under oath?
Yes.
Because I didn't, are we under oath?
No, you're not under oath. No.
Excuse me?
You're not under oath, sir.
Oh, well, do we need to be?
No.
You're not presenting evidence, you're giving an oral argument, so you don't have to be under oath.
Because I have no issue about being under oath. Okay, so fine. I just wanted to, the analysis is not accurate in the report. How it went by regarding the agreed upon date of the postponement was I was given the postponement notice, which was incorrect. We found out later. And but the notice, the form I was given, I spoke with the representative, Judith Graff of D.D. Howard. I never did speak with D.D. Howard. I only spoke with Judith Graff, and I spoke to her on the telephone, and we agreed, and she went back and forth, and then she came back to me and said that January 24th, I said that that wasn't a good date, the original date, And she also mentioned that that wasn't such a good date either because of the holidays, and that we agreed upon January 24th. I went to her apartment with the manager, the apartment manager, Lauren Wilkinson, who was in the apartment with me, and he is standing here, and he will be more than willing to testify. And we agreed upon, and Judith Graff filled out the form that I was given. Didn't realize that it was the inappropriate and wrong form because it didn't have a date. But we did agree on January 24th as the postponement date for the new hearing. And that was the end of it as far as I knew. And then I got a notice that the hearing was then redone for January 3rd. I was out of the country, and the hearings department asked to see my plane ticket, which I was in Burma, Myanmar, and I submitted that, and they still rejected it. And I never did speak to Dee Dee Howard, although the analysis says that Dee Dee Howard denied that she ever spoke to me. I never spoke to her. I spoke to Judith Graff. And I called, when I got the notice of January 3rd hearing, I called several times, as I detailed in my letter, several times, left messages, no answer from Judith Graff. I then called Dee Dee Howard, no answer. I then wrote a letter saying that we had agreed upon by Judith Graff prior of the January 24th hearing. And that's what I'm contending, that I did not have a due process. And if we'd like, Lauren Wilkinson can testify that he was in the apartment when Judith Graff agreed to January 24th. That's all I have to say.
Commissioners, do you have any question?
Just a quick one. Sir, you did not wish your representative to be at the hearing and to present on your behalf? If you were out of the country?
Lauren Wilkinson, it was a new manager, only a couple of months old, and he was not familiar with the entire history of everything that was being characterized in the decreased hearing.
And what about your attorney?
My attorney does not have the knowledge. And that's why we agreed upon January 24th with Judith Graff.
All right, thank you.
Thank you.
Mr. Braun, in the legal world, you know, we have these issues with laws of agency, and I know when you hired your attorney, you may have signed a power of attorney or something that he can represent you or she can represent you in your stead. And, you know, we have an issue here where you're holding out Judith Graff as a representative of Dee Dee, but do you have, were you ever presented any power of attorney, anything in writing that this person had agency for Dee Dee?
Yes, it was on the form. Judith Graff is written as the representative for Dee Dee Howard.
Okay.
If you take a look on the form, her name is on there.
Now, which form are you referring to, sir?
The decrease hearing form is listed her name as the representative.
It's page 20.
Page what?
Page 20 is the postponement agreement.
No, but the
Oh,
original notice that Judith Graff is the representative.
And staff, do you have any recollection of this form? Do we have this in our materials at all?
I think he's referring to the actual application, and I'm trying to find where that is in your packet.
Okay.
I'm sure I have it also.
We have it as well.
Page 49. Page 49, is that it?
And that's why Judith Graff signed the
It's 49.
postponement agreement, because she was
Yes.
listed as the representative.
Page 49.
Thank you.
49 is the MAR.
That's the application, I believe.
It is 49, that's
Yep,
the original
I see something on
hearing.
page
at
49.
Yeah, page 49 does say authorized representative.
Thank you. Commissioner Martz.
Yes, can you confirm who is SM Morgan Inc., the actual owner of the property?
Yes, it is.
Okay, that's all I have.
Commissioner O'Keefe?
Actually, no.
No? Okay. So very well, we'll move on to the other party. Thank you very much.
Thank you, sir.
Ms. Howard, yes? And you'll have 5 uninterrupted minutes to speak.
Right, I'm sure I won't need that long. I'm actually not sure what I should speak about. I was not here when he said he tried to call and left me a note or something. I was in New York. I have a place in New York, so I was there, and I never received any of that, so I don't know about that. And as far as Judith Graff, yes, she and I both came in as representatives for the whole building. You'll see on there are like 15 people that had signed. They asked for someone to be the person to speak and asked Judy at the time when she was with me, would she represent if I wasn't here, or would she be the person? I have no idea what went on, but I know Judy. I don't think Judy would be saying something that's not correct. I don't understand, if you did something like that, why wouldn't you have to sign, why wouldn't she have had to sign that she said that at the time? So maybe somebody can help me with that.
We can't answer questions. We can only hear your oral argument. Thank you.
So I'm not quite sure what else you all need from me. I'm happy to answer any questions, but I wasn't there. Okay?
Commissioners, any questions? Very good. Mr. Braun, would you like to rebut?
Judy, I
Oh,
think.
sorry.
I have one
we
quick
have
question.
one
I'm sorry. We have a memo in our packet from staff, just kind of summarizing what took place at the hearing. I'm just going to quote. It says, the tenant then requested that she misunderstood what a postponement was, and she wanted the hearing to be recounted as soon as possible.
That was
Did
not
you
me.
understand? I'm sorry?
That was not me.
Okay. Thank you.
Judy said, could she come up and speak?
Sure. How much time do we have remaining?
Well, now we're
3 minutes and 40 seconds.
I don't know. We have 3 minutes, 40 seconds. I mean, they have more time. They can speak.
So my question just is then, what did you think a postponement would or would not entail?
Well, I'm not even sure that that's referring to me, the comment that you just read. Doesn't sound familiar.
We just have your signature on this postponement form, Ms. Graff, about postponing the hearing.
Oh.
And we just wondered what you thought that meant, because you obviously objected to it.
Oh, no. I knew that when we originally went to City Hall, we were told that each party would be entitled to one postponement if they needed it. So when I was presented with the document, it said postponement, whatever, and I signed it because, he appeared at my door, and we had spoken on the phone, and I had spoken to Ms. Howard about, is that all right? Should we go ahead? It's the holidays. Sure. So when he presented me with a document, there was nothing written on it about a specific date. It was just a postponement. Mm-hmm. I figured that City Hall would tell us when we could come back.
Commissioners, any further questions?
I do have one question, completely off the subject, and but still relating to the case. There's the gate, the issue of the gate of the 14. I believe it's the security gate and the keys versus security code.
Oh, yes.
That's one of the items, correct? That you're receiving the decreased amount for, and that's under appeal as well, right?
I don't know that specific issue was appealed. I know that the landlord had disputed some of the findings of fact based on what the hearing examiner concluded. I don't know if that was one of them or not.
I think it said he appealed the entirety of the decision. I thought it said he appealed the entirety of the decision, as I recall, but I'd have to look.
Based on due process issues, and then he objects to specific findings of fact. But
Well, let me ask the question, and then we will ignore it if it's not relevant. The question I have is, so you received a rent reduction for the amount, or for specific to the gate, and not having a access code, but you all still have keys for it, right? I believe it's the entrance of the building.
Oh, well, we all have our own keys.
And you're able to allow other people in as well, or only, tell me how the gate works at your building.
Well, we have keys to get in the front door, and if someone, a visitor arrives, there's an intercom, and they have to call you. The problem is for things like newspaper delivery, fresh vegetables from
Yeah.
Bakersfield, you have to give them a security code so that they don't ring you at 4 o'clock in the morning.
Understood. So, but those visitors you do have come that use the box, the regular visitors, you're able to open the gate from your phone when they call
Yes.
upstairs? Okay.
Yes.
Great, thank you.
Do we have another minute or two that?
I'm going to defer to staff for this one. If we have,
If there's time left, then yes, the other tenants with,
can speak.
they're affected,
Very-
they can
thank you.
speak, yeah.
I wanted to
Bring up someone else to speak, they can.
Wendy Watts, yeah.
Hi, I'm Wendy Watts. I live in apartment 703 at Hayworth Tower.
Speak directly into the mic.
Oh,
Thanks.
sorry. I'm Wendy Watts. I live in apartment 703 at Hayworth Tower. I just want to bring to the commission's attention that the first hearing was scheduled on December 3rd, and Mr. Braun requested a continuance of that hearing. It was subsequently scheduled for January 3rd. All of the tenants appeared at the December 3rd hearing because we did not receive notification of the continuance. We arrived, we actually, I think, were sworn in only to be interrupted by city staff wait. Actually, it's been continued. So we were then notified of the newly rescheduled date of January 3rd. Again, we all assembled and appeared at that hearing. I see the document that I think Mr. Braun might be referring to with regard to the 124 date. Again, I wasn't privy to conversations between Mr. Braun and Ms. Graff about any rescheduling date, but as you can see here, it looks like there's an option to select alternative dates, and there's 124, 129, 131. However, the city chose the date of January 3rd, and it was properly noticed to all parties, and as discussed here, Mr. Braun's counsel did appear, as well as the property manager. You'll also note that this application was originally filed in July of 2018, so we are 9 months in now. Mr. Braun had ample notice of all of the issues that existed at the property in July of last year, in December of last year, on January 3rd of this year. His counsel was present and had an opportunity, of course, to prepare for the hearing in the event that her motion for a continuance was denied. So I would just offer to the commission that this hearing was duly noticed on December 3rd, on January 3rd. We all took the time out to prepare and appear, and we would ask you to uphold the decision of the hearing officer.
Thank
I'm
you.
happy to receive any questions.
Commissioners? No, thank you very much.
Thank you.
Mr. Braun, do you have some rebuttal time left if you'd like to use it? Yes, I believe your representative can speak, yes.
Yeah, and there are 2 minutes and 8 seconds.
Thank you so much, Mr. Trevor.
Hi, I'm Lauren Wilkerson. I'm the resident manager at Hayworth Tower. I just wanted to say that I was present when Mr. Braun went into Judy Grath's apartment to request for the postponement. He did mention that January 24th was the date that was agreed upon, and when she signed, that was what everyone was under the impression of the date for that hearing. So I just wanted to make that as just a statement, as you know, that it's clear that I was present whenever that was brought up. So I'm more than happy to answer any questions that you may have, but I just wanted to make sure that that was clear.
Thanks.
I have one question.
Sure.
Did you, were you sworn in at the hearing in front of the hearing examiner?
Yes, sir.
And did you provide sworn testimony about the conversation you just told us about?
Yes, sir, that's correct.
Thank you.
I'm not sure I heard you properly. Did you say that you heard them say the date of January 24th, or that you
Yes.
believe that to be the case?
That is correct.
And that conversation was when again? Just that a conversation where you're saying that you heard her say the 24th. That was early December, you said? When was that conversation with Mr. Graff? Meaning, you said you were in the apartment and you heard her say the 24th, and I'm just wondering when you had that conversation.
It was the date that she signed the postponement.
Oh, so that's back, yeah, so back in 2018 is what I'm getting at, yeah.
It was the
The
most
date that
recent.
this postponement was signed. Yeah, so 11/28/2018, so November 28,
Yes,
2018.
that's correct.
Yeah, thanks very much.
Mhm.
And, yeah, that's fine. I can just save it for deliberation. Any further questions, commissioners? No? Okay, very good. Thank you. Now, commissioners, we are open to deliberation. Just know the parties, this is a deliberation amongst the commissioners and the staff, if we have any questions for staff. So there's no further public comment from the parties. Commissioners, who would like to start deliberation?
I just have a question, so we can clarify whether the individual item of the gate is under appeal or not under appeal, if we have consensus on that or not. I'm just trying to find it in our packet exactly.
In
what
our
the-
packet on page 13 is the appeal to the commission, and A, B, C, and D are all checked. So it's being appealed that the determination is clearly in error, it's not reasonably supported by the findings, and the determination is abuse of discretion, and that it's contrary to specific provisions of the rent and stabilization ordinance. And then his attachment wasn't related to that, but I would think our responsibility would be to make sure there was substantial evidence to support the independent
I
each
guess,
of the findings based
would
on
it
the checkboxes.
help clarify on his attachment, the appeal? And I'm sorry, I hadn't thought about this before until we got here.
Well, I'll
Go
just weigh in. The regulation 60029 requires the appellant not only to check those boxes, but also to give the basis and any facts or arguments supporting that the grounds alleged in the appeal. And so because no facts or arguments were made on that score, I would argue that that is not under consideration by the commission. So that would be my advice.
Could you say
free to
the number again?
Sure.
The ordinance number?
It's regulation 60029.
It's regulation 60.
And so that would mean that page 15 which is 15 in our packet, which is his attachment to the document. At least I've read all of them, but for right now, this purpose, number one wouldn't be relevant because he didn't provide testimony in the hearing.
Well, his appeal doesn't state any facts or arguments supporting that issue that you're raising. What he raises
Number
in
one does.
I'm sorry, number one?
Page 15, the specific issues that he raises.
Yeah.
The tenants were never given the security code.
I believe is that in context with the evidence that he would present? Yeah, that evidence was not presented at the hearing.
Okay.
Ms. Regan, I just want to clear up an issue with this due process argument. For the sake of argument, even if Ms. Graff had given this approval on November 28th, 2018, there was a hearing on December 3rd, 2018, where that was revoked, where Ms. Graff, I see in the evidence here that Ms. Graff or someone appeared at that December 3rd hearing and said that they'd misunderstood the postponement. They wanted to revoke whatever that agreement was for, continuing this hearing, and that was revoked on the 23rd. And I just want to point out in the record that then we have a request to reschedule the hearing and appeal later on December 26th with, this is on page 21, Commissioners, with box 4 checked, have the other parties agreed to rescheduling? The box is checked yes. But in our record, I see prior to that, on December 3rd, that the tenant had revoked that. So I'm just, pointing that out to the commissioners that then we had a hearing rescheduled for January 3rd, 2019, the next year. And even if for the sake of argument that had this meeting occurred and had Ms. Graff given this consent, that it was revoked later in December.
Can we just finish or I'd like to turn back if you don't mind before
Yeah, go for
I
it.
discuss that to the question of the whether or not we're considering the other issues. And I didn't have the ordinance in front of me or the regulations. And so just so everybody does, it's 60029, you said? Acceptance of filing of the appeal? So it says, an appeal of a determination of a hearing officer will not be accepted for filing if, number 4, the appeal fails to state any facts or arguments supporting the grounds alleged in the appeal. I would think that accepted for filing would mean it wouldn't make it to us in the first place. Are you saying we rule against them in that circumstance, that accepted for filing means our decision?
No, obviously, they've raised some grounds, but they just haven't raised that ground.
Yeah,
And so 60035C says that the commission shall consider the hearing officer determination final with respect to matters not raised in the appeal. So if there are no facts or arguments supporting the grounds, then the regulations say that that aspect would not have been accepted, and therefore that's not considered appealed by the party.
But the discussion in the hearing, even though it was amongst the parties requesting the rent reduction, the discussion was some tenants had a long-term or had been given the code from the very beginning, and others had not. In fact, the hearing examiner even sets in their tenants after 2012, I think it was, get a rent reduction once before, or I'm sorry, before do get a rent reduction, once after don't. So even though it wasn't the landlord participating in that discussion, if they're appealing on that grounds that was not decided, does that qualify?
So you're saying that because even though it's new evidence, they've raised that issue. Is that what you're saying?
Is that,
and I think that's
I'm questioning whether it's new
supported.
evidence since the discussion was really had. It's just he wasn't participating in the discussion with the hearing examiner. Because the parties, in the hearing examiner's report, the parties had this discussion about long-term residents having the access to the code, and some didn't. And then some people weren't present, so she didn't know whether they did or not.
Right.
So the discussion occurred, it's just that he didn't add to the conversation.
It's not relevant that he participated. I think the question is this raised sufficiently in the appeal? And number one does raise the issue of the security code. So I think that's arguably, that's sufficient to raise, even though perhaps the grounds that if the commission finds that the grounds that he is arguing on don't support his position, I think at that, the commission is still free to make another determination, if you know what I mean.
Thank you.
So the reason I was wondering if this appeal was like a question included of if substantial evidence supported each of the findings was on the issue of whether or not the common area questions apply to all of the tenants that did not move in, that we don't know when they moved in. Because as I see it, there is zero evidence of when 5 or so, I'd have to double check, a number of the tenants moved in. And so I think there's zero evidence of the date they moved in, and there was the decision 1991 investments where they had the exact same thing, and they said essentially you can't show there's a substantial decrease in housing services if there's no evidence of when people moved in, and I can show you all that, the language, but just for your background, that's why I'm curious about whether or not we look at whether substantial evidence supports the decision in this case where they check the box but don't raise that specific argument. And I would think if they, my read of the language wouldn't foreclose us looking at that question. I don't think if they check the box in the appeal but don't specifically say the evidence on the record doesn't support this because there's no evidence of when the people moved in.
Yeah, I kind of had a question that's related, I think, to that for staff. It's just the way it's worded here in this is page 33 of our packet. It's page 7 of the hearing examiner's decision. Let's say the third full paragraph, the large paragraph in the middle of in the page where it starts, the guidelines value of vermin infestation, $42. My question is towards the end of that sentence, or towards the end of that paragraph, where the hearing examiner makes a statement saying, the record does not include the move-in dates for any tenants except those attending the hearing. The record is insufficient to exclude a tenant who did not attend the hearing on the grounds that he or she moved in to the property after 2012. Those tenants not attending the hearing are included in the rent decrease. The way this was worded to me seemed different than what I've seen in the past, and I was wondering what might be the logic there, because oftentimes we see that the hearing examiner usually wants to know if there's a tenant in each unit, and when their start date was, and why would this apply to all of them since only the pest control portion would only apply to people who had that service when they initially moved in?
Right. So I'm not sure if that general question is appropriately before you. I don't believe that it is, because this is not this wasn't appealed by the landlord. But having said that, I will say that the ordinance under common area rent decrease applications says that it will apply to all other tenants shall be deemed applicants and shall be entitled to any rent adjustment awarded in the hearing examiner in the hearing decision. So essentially, the practical effect of that is to create a presumption that can be rebutted by the landlord. So the landlord needs to come forward with some evidence, because obviously the applicant won't have any idea when the other tenants came in, and should not obviously be
I think that
responsible
was
for
my
finding
question.
out that information. So the landlord is in the best position to have that information, and usually does come with a rent roll. In fact, I think the handbook says to the landlord to come to these hearings with a rent roll, particularly when there are common area issues. In this case, obviously, we don't have anything from the
But
landlord.
the hearing examiner is ordering it for everyone, with the caveat, unless they weren't there before 2012 or the date. And the landlord can show that.
Right.
And that would justify, it would be justification to show the city. The city would look at that and review it and say, okay.
No, the city's not a party to this case. So
But I mean, when he files for a rent or when he files for compliance or these people wouldn't be allowed. Who's going to determine whether these individuals that are unknown qualify for the rent decrease or not?
So the hearing examiner has already awarded these rent decreases. So if the landlord complies, then all of those people, those rents will be restored.
But if not, then any of the unknowns automatically get the $12 or a
Correct.
$10
If you look
reduction?
at the end of the decision, because the landlord didn't present any evidence as to when these tenancies began, she applied the rent reduction to them all per the ordinance. And again, if the commission is going to hear this, I think all of you need to decide that it's appropriate for that aspect to be heard. I don't believe this was raised on appeal. So I think collectively the commission needs to agree that this is an appropriate area for you to rule on sua sponte.
So here is my feeling on this matter, that there was a hearing scheduled for December 3rd. The landlord asked to have that rescheduled. The tenants, in some fashion, agreed to that. On the 16th, the landlord again claims that he asked to have it rescheduled. There is nothing in our record showing that. We have a he said that, I talked to this person, this one said yes, but we have nothing in our record that says, yes, they agreed to yet another postponement after January 3rd. So the parties appeared on January 3rd. The tenants came, the landlord's attorney, the landlord's on-site manager. If there had been a written document saying, yes, we requested this, I would say that perhaps the hearing examiner could determine whether it would be appropriate at that point, but there's nothing presented at that hearing saying that we were going to be postponing the issue. So for me, these other issues brought up by my fellow commissioners about whether all tenants are included or not is not relevant to tonight's discussion. That what I think that we are discussing in the appeal is the landlord is saying that I wasn't given the opportunity to present my case. I wasn't given the opportunity to present evidence because I was refused another postponement of the hearing. And I would disagree with the landlord's that landlord's thinking on that. I would be in favor of upholding staff's recommendation that there was adequate notice, There was no guarantee that they were going to be given that second postponement. The tenants did not agree to a second postponement. The hearing went forward. The landlord had their representatives there. They had ample notice. They chose to leave the hearing and not present evidence, and that's just how this matter ended. So I don't, for me, I don't think it's necessary to sort of relitigate any of the decisions for the issues brought by the tenants because it's not relevant to tonight's hearing.
Did you want to speak, Karen?
It was on the other topic, so if that's all right, yeah. I just want to quickly hand out, so people have the 1991 decision, and direct your attention to page 20, which is highlighted. I'll read from it. The reason I'm concerned is because there was almost identical ruling where the commission on this one piece. And they found, as you'll see, the RSC's across-the-board rent reduction for each tenant, however, is not supported by substantial evidence, and that there is no evidence at all as to when each tenant moved into the property. For example, a tenant would not experience a substantial reduction in housing services if she moved in after the turtle fountain was no longer working, ... The city presumably has all of this information in its much-discussed registry database, but chose not to submit any of it. This failure undercuts the decision to reduce all of the other tenants' rent. So I would be concerned with upholding any decision on that piece if it were before us, which is a question. But I just wanted to make sure you guys had that for all future decisions on this point, and if people agree it's before us for this one.
While I hear you, I just feel that that is not what we are being asked to consider in tonight's hearing. That for me, it's fairly clear-cut that the landlord and the representatives chose to leave the hearing and then did not, because they left, did not submit any evidence. We cannot consider anything new, so this is just our agreeing with staff's recommendation that because the landlord chose to leave the hearing, that it had already been rescheduled. So I understand where you're coming from in the 1991 decision about the substantial reduction in housing, but I don't think that is relevant to tonight's appeal.
I'm going to have to concur. The tenants have been prepared for 9 months, and the owner himself has had that opportunity to be prepared for 9 months and has not been. And it seems like these tactics have been delay, delay, delay. And it has to be resolved.
Before we get too far, so let's back up just for one second. I think that what is being said here is not that, so let's say, it's not that the testimony wasn't given that contradicts the tenants, because the landlord could have been at the hearing silent or provided identical information. What I think Commissioner O'Keefe is saying, and what I'm also talking about, is the hearing examiner then leaving the hearing and evaluating the testimony that she heard and coming to the conclusion that she did. And so the landlord wouldn't know, or no one in the room would know, to make the argument that Commissioner O'Keefe is making, because we don't, all we know is that the residents testified, this is when I moved in, this is what it was when I moved out, or the information I had, or the codes, or whatever it was, the services were provided when I moved in. We're talking about the unspoken testimony that was, that the hearing examiner on her own applied to those vacant apartments. Is that correct, Commissioner O'Keefe?
Yeah, I'd say to me, it's the question of, is there in my reading, by checking the 3 boxes, 4 boxes, the issues before us, is there or is there not substantial evidence to support each of the conclusions? And so I thought, for that reason, we need to look at it, and if the absence of evidence means there's not substantial evidence, I would say that we would need to overturn in that narrow piece just for the people, the apartments that we do not know when they moved in for the 2 that were not code issues, that were instead substantial reductions in housing services.
Because it would be impossible for anyone to have participated in that debate there, because it never came up by anyone. This is what the hearing examiner is putting on after the fact, based upon the individual testimonies of each of them. So none of them will be affected in what I'm referring to.
Yeah.
It's the vacant units that I'm referring to that I have issue with. If that clarifies, hopefully.
I'm going to, excuse me, I'm going to jump in here. I think the first issue that I want to bring up is due process. I agree with some of my fellow commissioners that the parties have had ample time and have had ample opportunity to present their cases, so I don't agree with any of the landlord's arguments that that opportunity was not presented, especially when a corporation or another entity that's not an individual person doesn't have, you know, you or I standing in as an individual owner. You can have an authorized representative, and there were people there, the attorney, the property manager, to make the case, and the decision to leave was those parties. And second, I think there is ample evidence to support the hearing examiner's decisions here. We aren't there to hear everything that they're saying, so we have to take what's written as the record. I think the testimony that is written into the record supports the findings, and then also the hearing examiner is the one that is in the best place to make that decision. And so I don't see anything in the record in the oral testimony today that would make me want to change what we've seen here today. So I would vote to follow the staff's recommendation.
Can I ask you, Commissioner, on page 33 of our packet, 7 again of the hearing examiner's decision, she states very clearly what the administrative precedent has valued monthly exterminating services in the common area of $10, support an evaluation and a rent decrease in the amount of the pre-2012 tenancies. So anyone before 2012 gets the reduction. The record does not include the move-in dates for any tenants except those attending the hearing. The record is insufficient to exclude a tenant who did not attend the hearing on the grounds that he or she moved in to the property after 2012. Those tenants not attending the hearing are included in the rent decrease. That to me seems like she basically is saying that she recognizes the fact that the service only applies to people before 2012, and she is coming to her own conclusion that all tenants should be, all tenants not in attendance should be included in that. I would be fine with that if there were an exception that said, unless the tenant moved in after 2012, then they're not.
I think our legal counsel answered that question, that there's a presumption in the regulations in favor of the common area tenants, and the landlord then can rebut that presumption by not attending the hearing or leaving the hearing early. They didn't rebut that, and so the presumption stays in favor of the awarding it to all common area tenants, and that's kind of where we're at now. If there was even a lick of evidence that this did not apply to X, Y, and Z tenant, then we could discuss that. But since they left the hearing and did not present anything, I don't think there's any reason to disturb the hearing examiner's decision.
But the hearing examiner didn't discuss amongst the tenants whether their neighbors would receive, she concluded this on her own, and the neighbors didn't offer any evidence to show that their neighbor lived there before 2012. So I don't see any evidence either way. Maybe I'm not understanding how it works, but it seems to me that she says there's not enough evidence.
Do you mind reading that regulation again? It might assist us here.
And Ms. Riggin, what's the section number you're going to read?
It's 17.44.010. 1A, it's the last sentence. All other tenants shall be deemed applicants and shall be entitled to any rent adjustment awarded in the hearing decision.
And that's consistent with all our prior case decisions, similar.
And Ms. Regan, I hate to keep drilling this point, but that is for the 90% of the time, all of the common area issues that we have are, was it painted before, is it painted now? No. Was there carpet before? Is there carpet now? No. It doesn't matter if the tenant moved in 2010 and the carpet went away in 2014, or if the landlord or the hearing examiner always lists who gets it, who receives the decrease.
When there's evidence.
Okay.
Chair, thank you. I would just, I appreciate the discussion brought up by Commissioner Kerpis, because that was definitely a question we wanted to hear. And however, I'm still convinced that the issue before us is that pertains to the due process, whether the landlord was denied the due process here, and I don't really see that. And I believe that the examiner's decision in the case is correct, and I don't see any error. So I don't believe that there was a denial of a due process. This is a LLC. The landlord had an opportunity to have a representative to be present, an attorney and manager. So it didn't convince me that, when the property owner stated that the manager was new or the attorney was not aware of the issues, that's really irrelevant to me, because there was the date of the hearing was known to the owner. I think the due process was followed, and I really don't believe that the examiner erred in the decision. So as in regards to what we just discussed, and Ms. Regan read the RSO section, which always been there, and that's the precedent. It's not even precedent, that's the RSO provision we always enforced in all our prior cases that had a similar set of facts, and we applied the rent decrease to that would be considered a substantial reduction to all that would apply to all other tenants that are not applicants. So I'm in full agreement with staff's recommendation. I'm going to support the staff's recommendations to affirm the decision. Thank you.
Commissioner O'Keefe.
I'd just note that whatever ordinance says, it has to be interpreted in a way that's constitutional and consistent with statute. So there's many times where ordinances read one way, but courts rule that that's not what they mean. For example, in Georgia, there was a statute that said you couldn't wear a mask. Court said that's not constitutional. It's only if you're wearing a mask with intent to terrorize somebody. So if the plain reading of the ordinance sounds like it would apply to everyone, that if courts look at the broader state and federal constitutional and state law that authorizes and restricts rent stabilization ordinances and says, no, you can't lawfully do that, we need to abide by the larger constitutional context. And of course, this is very, very part-time for all of us. We haven't had time to look over this, but I would just urge that whenever we have a ruling, if an ordinance is not consistent with well-reasoned or binding decisions on how it's interpreted, that we bear those in mind. And in this case, there was a court decision that had the same ordinance that was in place, and they overturned an almost identical decision on this narrow piece.
Commissioner Maggio.
I think I've said enough, but I do support the staff report 100%.
I'll go on the record and say I'm inclined to agree with Commissioner Kerpis and O'Keefe, actually. I do see that they checked the box saying they appealed the decision based on substantial evidence. I'm looking at a decision that was overturned in the city of West Hollywood talking about substantial evidence, and that they did make this determination pretty much along the same lines as that we have. But, that at this point makes it a 4-3 vote if we're going to go ahead for this. Commissioners, if no one's more persuaded one way or the other, then that's just where we stand. If anybody's anything further to deliberate, though, we can continue.
Yeah, before we jump on the next one, I'll talk about the three things. One, I also agree that that it is okay to proceed, that the hearing examiner made the right decision by proceeding on January 3rd. And the reason I'm coming to that conclusion, even though I think that our forms are confusing, and even if everything is absolutely true what the landlord said about, there was an agreement on January 24th or 23rd, whatever the date was, the form that they actually signed clearly states that the party, the tenant, can revoke that at any time. And so because of that, even though there may have been a misunderstanding of what form was properly used, the words on the form specifically state that. So I'm satisfied that the hearing examiner made the correct decision to proceed on January 3rd. I'm just going to touch real briefly on the one issue we have been discussing, and that's those vacant units. So by my count, there were 21 units in total that the hearing examiner is making a decision about in this decision. 7 of those, we know the date of when they moved in. 2 of those were before 2012. So she's making a decision about all 21 based upon 7 that she knows, and only and there was, not half obviously, but 2/7. 2/7 of those were moved in prior to 2012, and this would apply to. Most of the units it would not apply to. I may have that backwards, the 7-2, but it is 2 and 7 that apply or this qualify or not qualify. So I'll stop talking about that. The last thing, the reason I brought up the gate is because the hearing examiner, in her decision on the gate issue, applied a $14 a month valuation on the security gate based upon it being a security gate, and that was the full value the security gate lists, I believe is what she said. I don't have the list here in front of me, but I believe her argument was the guidelines.
Can you share a page with us?
Page
34, I see.
34, yeah, 8 of her decision. Again, in the middle of the page. The guidelines do not provide a valuation for access with a security code, but they do value security at $14. Fisher testified the security code is convenient to give visitors. I understand the whole purpose of why it's, but the valuation was set upon establishing security. It's definitely a secure building. It's just a matter of the convenience portion. So I think that she erred in valuing it at the full $14 for the security, because they still have security. It's just inconvenient because of the morning deliveries and stuff like that, or being able to give friends the code to just walk into the building. So that's why I brought that up, and I think that should be lower, but I'm not going to oppose this whole thing just because of the $14. But I just want to point that out so that we are consistent throughout. As the hearing examiner judges these, and as we look at these, that we're consistent in the valuation that we provide off of our guidelines.
Well, there is a guide, we have our guidelines, and we can lower that number if you feel that we should or could, but I don't have those guidelines in front of me, but I think the lower amount is $8, if I'm not mistaken.
Mr. Kirby, if you want to look at then the draft resolution RSC 19-548, do you want to propose an amendment to that might reflect your concerns about the valuation for the security buzzer system, for lack of a better word?
I mean, I would take the lower of the guidelines if there's a range. I just don't have them here in front of me. I think they're in the back of the regs.
I'm just going to jump in and say I wouldn't agree with that as well. We have no other evidence that value is not appropriate. Again, the hearing examiner was the one that was there, and since the security codes are not in our guidelines, it's up to the hearing examiner to come up with that. And I think not having a code can be consistent with just plain security. So, again, there was no evidence presented to us today that was out of line, and so I just don't see any reason to disturb what we've been given today.
And I would agree with Commissioner Mart's comments. I don't believe this issue is directly before us, and although I have no problem on discussing on the matter of the guidelines as I do it myself. Typically, if I disagree with the examiner's determination on the amount of the rent increase, sometimes it's too low. It doesn't really reasonably support the amount, the value of the service that was lost. But I don't. That's for those cases when you're specifically reviewing that type of issue. Here, I still, although I appreciate Commissioner Kurpis, and I was quiet because I wanted to listen to all the arguments, but I truly believe that today before us we have the due process issue, and that's the only reason I think that we should kind of focus on the due process matter. Although some of the arguments you made, I would agree with them. So that's why I wouldn't really support the amending the resolution, the motion that we have before us, because I don't believe that is directly a matter that we should discuss tonight. We have the due process issue, so kind of reminding them. Thank you.
Would we like to try for a motion, and we could always have further discussion
I
after
could
it?
make a motion, Chair, if I can.
Yes, I'm open to accepting motions.
I'd like to make a motion to adopt resolution of the Rent Stabilization Commission of the City of West Hollywood affirming the hearing examiner's decision on application D-4363 pertaining to the property address 1314 North Hayworth Avenue, apartment number 201.
I would second that motion.
Very well. Any further comments? We have a motion on the table. Very good. Mr. Trevor, may we have the vote?
Commissioner Kurpis,
No.
Commissioner Maggio,
Yes.
Commissioner Martz,
Yes.
Commissioner O'Keefe,
No.
Commissioner Topchian,
Yes.
Vice Chair Bergstein,
Aye.
Chair Charity.
No. Thank you very much. The motion does pass. Parties, if you have any further questions, please refer those to staff. But as you heard, the appeal was put down. The hearing examiner's ruling was affirmed. Yes, we've been, have a requested break for 2 minutes, and then we'll move on to our next appeal. Okay, Commissioners, we're going to come back into session and go on from Appeal 9A to Appeal 9B. This appeal is D-4393. The address is 1022 North Vista Street, Unit 7. The appeal, excuse me, the appeal was filed by Miguel Lozoya. Is Miguel here? Yes, thank you very much. I don't see anybody else present for the tenant in the audience. So at this time, may we have the staff report from our attorney, Ms. Regan.
Yes, Javier Malero rents a room in Unit 7 from Miguel Lozoya. Mr. Lozoya has rented the unit from the property owner, Joe Weisenfeld, since 2005. Mr. Malero filed an application for a determination of the maximum allowable rent and a determination whether Mr. Lozoya had accepted rent in excess of the MAR. The hearing examiner determined that the MAR for Mr. Malero's tenancy is $515 and that Mr. Lozoya has retained excess rent in the amount of $2,872.47. Mr. Lozoya timely appealed, claims that he and Mr. Malero had oral agreements for the rent increases and that he believed those increases were legal. He claims that he did not understand the city's ordinance as that it applied to him and the rent he charges his roommates. Staff recommends that the Commission affirm the hearing examiner's decision. Under the RSO's definition, Mr. Lozoya is considered a landlord who is subleasing part of his unit to a subtenant, and a landlord may not increase the rent above the allowed MAR. In addition, any such rent increases must be in writing. Because they were not, he collected more than he was lawfully entitled to, and those amounts must be refunded to Mr. Malero. A landlord also cannot unilaterally change the terms of the tenancy, and when Mr. Malero moved in, utilities and internet service were included with the rent. Mr. Lozoya began charging for those services without Mr. Malero's written consent, and those amounts too must be refunded to the subtenant. Thank you.
Thank you, Ms. Regan. Questions for staff?
Allison, so therefore, because October 2018 was a written notice, then the maximal allowable rent would be based on that date.
Right. One of the rent increases was in writing, and so he was allowed to apply the correct increase. It just so happened he applied an incorrect rent increase, but the MAR that the hearing examiner determined did include the lawful rent increase for that year.
Okay, thank you.
To your knowledge, have we had prior cases where there was a tenant renting part of their room out, or is this the first time, part of their apartment out?
It's not the first time, but it's rare.
Thank you.
I have two questions. One is, so the hearing commission or hearing examiner cites state law for the written notice, and I did look that up. It does appear to be very clear on it being written notice, but I just wanted to make sure that there aren't any exceptions to that because of the rent checks were written every single month, that after the 60 days or the 30 days of writing the checks, does any of that apply? Since, you know, the primary purpose of the written is so that nobody's surprised, you have proof and record and all that stuff. There's no case law that you know of that would allow for an exception of me writing a check to you each month. After like the third or fourth month, it's implied that I've gotten the increase because we've agreed on this and continued to write for rent.
It's not a question of whether they've made an agreement, it's whether or not there was actual written notice.
Okay, and so that's what I'm asking. There's
Has to
no,
be in
because
writing.
the check is writing, okay. And then the other question I have is, I think the rents here are low enough to where it doesn't apply, but isn't there a MAR for the unit as well? To where, and this is kind of more of a warning for other landlords or other tenants who may be subleasing, that if your MAR is, regardless of how many rooms your apartment is $1,200 a month, and that's the maximum amount your landlord can charge you, you can't then charge your subleased tenant more than that.
Well, the MAR for the subtenant, as in this case, depends on what the initial, it depends on the factors outlined in the RSO, but yes, there's an argument to be made that even that initial rent can't go beyond what the master tenant is paying.
Allison, wouldn't that be a separate agreement and would not really have anything to do with the maximal allowable rent of the apartment itself? The separate agreement would be, this is what I'm renting you the room for.
Right.
So that would be separate from what the...
I hesitate to get into hypotheticals because it
All
really
right.
is fact-specific, so I'd rather focus our attention
All
on...
right.
Commissioners, Mr. Burks. Commissioner Burks.
So on page 119, there's a line that says, a re-registration form is not required for Malero's tenancy because there was no vacancy in number 7 when he moved back. Am I correct? And this is because the city's relationship is with Mr. Lozoya, who rented the apartment from the owner of the building. The city really doesn't have that relationship as a tenant to Mr. Malera. There was no vacancy. We don't have to file a re-registration form when a roommate moves out or a subtenancy. It would only be if Mr. Lozoya, who has the lease with the owner, had moved out. At that point, there would be a registration. But each time a roommate turns over, there is no requirement by the city for a re-registration because the unit itself has not become vacant. Is that
That's
am I
correct.
correct? Thank you.
Commissioners, anything further? Very good. Mr. Lozoya, you're able to speak for 5 minutes.
So hopefully you can understand me. The thing is, I requested a different resolution or an appeal because for those two rent increases from 2012 to 2018, those oral agreements, I was under the impression that oral agreements were okay, were admitted from prior apartments that I had, with office managers telling me that between roommates, you don't really need agreements and forms because sometimes family moves in together. Like in my case, my older brother moved in with me, my first apartment. Boyfriends, girlfriends, so we don't really need, that's my understanding, that we don't really need, except for the office, they actually do want like a basic document with information from the person who, because they want to know who's staying in the building. That's what I was told years ago from my previous places, and that so that oral agreements between roommates, if there were both parties were okay with the agreement, then it was fine. It was okay, and that's what I did with my with this roommate. I've been renting him for like 6 years, the living room for like six years, and we never had any problems. Every time I never really wanted to like increase the rent because I not just the rent back then it was kind of low. I think the percentage was about 1.75%. I think it was. So every time the rent increased, it increased for like $20-something or $30-something, and I would just pay that year after year after year. Keep the rent low for the living room and the second bedroom, so that it will be like easy because people don't really want to rent the living room. They want to. I mean, it's better if you rent it cheap. So I always kept it cheap like that. And then when I rented when I increased the rent, I did it like every few years. And the next year I will take the increase. And then when a roommate will move out or the second bedroom, maybe sometimes I will raise it a little bit, but not too much because I still want to be able to rent it because people are not comfortable with the living room situation, right? So I also to keep the rent pretty cheap. And about the utilities, 'cause I went to the housing rights center, I think in Wilshire, and that's where they gave me that form. But they told me how to fill it out. They told me I can fill it out that way, that I can, do the increase according to the city ordinance. I think it was 3%, and you can split the bills evenly to 3 ways. So that's what I was told, and I was told I could fill out the form that way. But I mean, I'm not really a landlord. I don't really know the laws and all the stuff. I mean, last year I made $26,000. I mean, I don't really know the proper rules. I always try to keep things kind of in a loose, friendly manner with my roommates. never really had any problems except for certain rooms that kind of move out without any notice, or that's basically been mostly my problems. Usually, I always try to, like I say, keep the rent pretty much low, and then occasionally when the rent goes up, then yeah, I gotta like increase the rent either in the second bedroom. When somebody roommate moves out, then I got a new roommate. I will increase a little bit. But this roommate, Javier Mulero, has been there for like almost 6.5 years. I mean, he's been there the longest. Usually, nobody has stayed in the living room for more than 6 or 8 months. It's a temporary thing. People just move out. He's been there. I mean, he has problems. He's 55 years old. I understand he has problems. But I mean, for 6 years, I mean, I had to like raise the rent. I mean, my problems, I didn't know that I had to raise it year by year by year by year with a document. I wasn't aware of that. I just thought maybe do things kind of have oral agreements and keep it friendly, keep it loose. And yeah, when roommates moved out, they would just tell me, Miguel, I'm moving out, I'm moving back to France, I got a job in Atlanta, or stuff like that, but they let me know like 30 days in advance. Okay, no problem. And so that's why I was kept between roommates, because between roommates kind of like, kind of casually, just because people don't really like to, my experience, people don't like to sign documents. Roommates don't like to sign nothing. And then I don't like to do those kind of agreements also, because it's kind of, I mean, people are just roommates. You keep it friendly, just do oral agreements. And anyway.
Thank you. Commissioners, questions? No? No questions? Very good. Oh, thank you, Commissioner Bergstein.
So you just stated that you're not really a landlord, but sir, you are a landlord in the city of West Hollywood of a rent stabilized
Yeah, I
unit.
mean,
So
now I understand
so
that.
let me finish my question.
Sorry.
So did anybody at the city of West Hollywood rent stabilization department down at City Hall tell you that oral agreements were binding, that your oral increase in rent was a legally binding increase in rent?
Have you been told that? No.
Okay. And when you went to that, did you seek advice from the City of West Hollywood Rent Stabilization Department about changing the terms of your tenancy to begin charging for utilities and internet?
Yeah, well, actually, every time I went to ask questions here in West Hollywood, I always kind of felt a certain pushback, a certain.
So did you ask anybody at the City of West Hollywood Rent Stabilization Department if you were allowed to change the terms of your tenancy by charging for utilities and internet?
No, not West Hollywood. I went to the housing center in.
No one at West Hollywood. Thank you, sir.
Commissioners, anything further?
So I'm going to let you answer your question. So you went to City of West Hollywood to ask questions, but how did you feel?
I felt like there was a little rejection, because every time I asked a question, they were like, they didn't know what to tell me. Once one person from City Hall told me to go to Plummer Park to talk to a lawyer. This lawyer, so I went there, but the lawyer was really, very, extremely rude with me. He screamed at me, "You're a landlord, you're a landlord." I was taken aback. I was expecting that kind of reaction. So I just kind of have a few questions. They told me I went to City Hall because I was having problems with my roommate. Because back in
No, I appreciate that. I just wanted to give you an opportunity to kind of you gave the answer. Thank you
sorry.
very much.
I just have in 2013 and 16, when you had rent increases, there was no written notice.
No.
But in October of 18, you gave a written notice.
Yeah, that's after I went to the housing center. They gave me that notice.
So you realized that you had to start doing it by writing. Is that correct?
Yeah, well, that's at the housing center. They suggested that I kept doing that. I started doing that what we done before, doing the oral agreements. That I do the written notice.
Okay, thank you very much.
Sorry.
Commissioner O'Keefe? Okay, no, I don't have anything. Okay, very good. We're going to move on to deliberation. Thank you very much.
Thank you.
Commissioners, who would like to start?
I would just say that this is rare. We have not had too many cases like this come before us, but people have to be aware that if they do rent out rooms, the laws that are provided with the rent stabilization ordinance are related also to these issues. And you have to have a written notice. That's the best way to always do it. So I'm certainly in agreement with the staff report.
Commissioner Keefe.
I think it looks like a pretty clear-cut legal issue. You know, I looked in the definition of landlord, the definition of tenant, the definition of rental unit, all seem to pretty clearly apply in this case, one or more rooms for a dwelling. That said, I think that it's not good policy to treat a roommate situation exactly the same as a savvy landlord, and that this is an example, but that's not our role. So I think given that the law is pretty clear here, I think I have no choice but to say I would uphold the hearing examiner's decision, but I'd like to discuss the issue of the policy behind it at some point and whether it'd be worth considering having a different set of rules for a roommate situation. Because in some cases it could be devastating if somebody in good faith thinks they're doing right, you know, isn't aware that they have these obligations and ends up owing a lot of money that they might not have.
Yeah, but there could be these tremendous variations from year to year. Then if you don't have that agreement, it could be $500, and next year it's $650. It's better to have the rules in place, I would think.
It's a different discussion, but I'd say maybe different rules, but a little different.
Commissioner Thompson.
Yeah, thank you, Chair. Yeah, I agree. It's a kind of a cut and dry case before us. It's the RSO clearly defines the landlord and the tenant in this situation. In this particular case, obviously, Mr. Lozoya, although he's a tenant, but he is a landlord. He's acting as a landlord by renting a room and increasing the rent, providing a service or taking away a service, collecting rent. So clearly, he's a landlord. As defined under the RSO as a landlord, he's charged with the responsibilities as any other landlord would be. As a tenant, I believe that Mr. Lozoya receives annual rent increase notices from the landlord, and therefore he should be aware that, or should have been aware that any rent increase should be in writing, because he himself receives the rent increase notice. So the same courtesy or the same law should apply to his roommate who to whom he is renting a room and is collecting rent. He is benefiting from renting out the room. So I like the policy, although we're not discussing the policy here, but I think the policy works, especially in the city of West Hollywood, where we historically have really high rents, and it's a common situation when you see if it's a 2-bedroom apartment and a living room is rented, 1 bedroom is rented, another, the roommate to roommate situation, it is defined as a landlord-tenant situation, and I believe in that case, a master tenant, if the master tenant is collecting rent and acting as a landlord, then should have a responsibility of a landlord as defined under the RSO. So therefore, I fully agree with the staff's recommendation, and there is nothing here that I would disturb. So I'm going to support. Thank you.
I'll go ahead. I agree also with the staff recommendation. What everyone has said, the legal issue is pretty clear. We can discuss policy at another time, but the facts as they apply to the law that applies to this case, I think is abundantly clear. I want to speak to Mr. Lozoya directly. I want to thank you for coming out and speaking to us. I know it's difficult to come before us and do an appeal and speak in front of all these scary-looking people, but whatever way we rule, I do appreciate that. And this is a good lesson that laws sometimes apply to us when we don't expect it, and it can be an expensive learning lesson, but going forward, hopefully, things can be understood that there's laws in place that have to be followed, and they protect us as much as we have to follow them. Sometimes they protect us, sometimes they harm us, but they're in place for a reason. So those are my comments.
I'm inclined to agree with everybody else. I don't have anything further to say.
Yeah, I would echo Commissioner Marsh's comments, and especially the comments made to you, Mr. Lozoya. I guess we just take this as a learning experience for the future, but the law is pretty clear, and we have these laws set in place to protect tenants, and so as was said, sometimes they don't work out the way we thought that they were supposed to work, or they apply in different ways, they sometimes feel, but in this case, it is applied correctly, and unfortunately, it's the way it turned out for you.
I'm ready to make a motion, sir.
Very good, thanks. I think we're ready.
So let this be a resolution, RSC 19-549, which is a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming the hearing examiner's decision on D-4393, 1022 North Vista Street, apartment number 7.
And I'll second that motion. Mr. Trevor, may we have the vote?
Commissioner Kirby's,
Aye.
Commissioner Maggio,
Aye.
Commissioner Martz,
Aye.
Commissioner O'Keefe,
Aye.
Commissioner Topchian,
Aye.
Vice Chair Bergstein,
Aye.
and Chair Charity.
Aye. So the motion passes. Thank you so much, Mr. Lozoya. I do apologize on behalf of West Hollywood for your not great experience with some of the prior people that you interacted with, but I can assure you that the people in this room are very friendly. So if you have any questions, please hang out and ask us questions, and we'll be happy to help you out if you have anything. Moving on, at this time,
Can we just be sure that he knows what his options are in terms of whether he has to directly pay the tenant or if he can just absorb the costs over time?
That's a good question, so that he's not confused by that.
thank you. Moving on from our appeals, item 9 to item 10, public comment, and I don't have any. Moving on from public comment to item 10 to item 11, commissioner comments. I just have one. I do think the second appeal gives us an opportunity for a learning experience, and maybe we can add something in our the tenant workshops that we have, maybe explaining that if you do sublease that you're a landlord. I think it's a bit more common than we think it is. I have done it moving in a significant other, and I know I have neighbors that have done it and other friends that have done it when a roommate moves out and they replace that roommate and they arbitrarily give that new roommate a rent. That they are subject to our RSO. I think it's something important to share. Then I think that if it gets out there that these lessees can start applying for MAR determinations, that I think we'd see a lot more of these, because I know it's going on a lot more than we've seen in our appeal.
And it's more common now than it has been.
Yeah, I think it's very common.
Maybe for our study session, I'd be curious as to discussion. Commissioner Kirby brought up that if a tenant is renting a rent-stabilized unit and then subleasing out rooms that may be in excess of what that master tenant, for lack of a better word, is paying to the owner of the building, if that, I think it's a sticky wicket, first of all, for any tenant whose lease doesn't allow for subleasing, they could end up losing their rent-stabilized apartment, but just maybe a discussion for our study session at some point to add that to our list.
I actually was curious about that myself and was poking around and found that in San Francisco, they actually have an ordinance that limits the rent charged by master tenants to the proportional share, and I thought I'd just pass it out so people know what another city is doing on that piece. I wouldn't want us to waste a bunch of time if the city council wasn't interested in us doing it, but I would be interested in us exploring what rules should apply to tenants leasing out rooms. I do think it's important to have some kind of notice and some kind of limits on the increases year to year, but treating them exactly like every other landlord, I think there are many ways in which that could end up being problematic. So for example, the prohibitions on eviction are very limited for a landlord. If you're living under the same roof as somebody and say they make you uncomfortable, they're allowed, there's all kinds of things, and there's the housing services that are provided by roommate to roommate, that you would then have the tenant roommate being able to have the rent decreased but not have the similar obligations. So I just think there are a lot of issues that I feel like maybe weren't necessarily, I don't know, maybe, I'm assuming they weren't considered when it was written and it was just kind of added in, but I think that a roommate situation is worthy of production but worthy of a lot of thought in what makes sense and what doesn't.
But I will say kudos to West Hollywood. I mean, it's clear that our appealing party tonight did get the message at some point, even though it was gruff, that they were a landlord. So the kudos to West Hollywood for somehow getting out that message. So Any further commission comments?
Yeah, I'll be brief. I commend Commissioner Bergstein for using sticky wicket tonight. That's a good phrase. And then when I was in law school, the weird way that I got into landlord-tenant law as my first area of law is because I had to sue my master tenant directly under this rent board topic. So if you ever want to talk about that, I can show you the good and the bad. But I think on the flip side of that, sometimes our master tenants are not savvy and that they, might get caught up are these, is that the subtenant is the one that we're trying to protect. And, at least in my situation, my master tenant had lived there for 20 years. Her rent was $1,000 in San Francisco for a 3-bedroom. I was paying $1,500 when I was in law school. And so one of the things that I think is the best ordinance that they have, which is also the most simple, is that when you move in, you have to give your lease to your subtenant so they know what you're paying. And then it kind of creates this, we can talk about it, from the very beginning. And then if they don't, then there's issues. So, we can throw that into a study session and go deeper into that.
Thank you.
I just have two things. One, not that we're discussing this, but I'll add my 2 cents into it. For the, I do think we need to have a discussion, or at least have a discussion about doing have a discussion at our study session, possibly about doing more somehow, whether it be through the tenant workshops or something, just so we do get the word out about this, because it also applies to tenant relocation fees, which that would be a huge dent to your pocketbook if that were a surprise to you. And I don't think people realize that these tenant or these roommate issues or these roommate situations are tenant-landlord issues. The second thing I wanted to mention was not as good, well, not that the other one was good news, but so AB 36, which was the Costa-Hawkins, amending Costa-Hawkins to allow for rent control to apply. It actually started out, it would apply to anything older than 10 years old. This is in cities that have rent control, by the way. The cities could expand it to any property older than 10 years old. That got amended to anything older than 20 years old. And it included also, it went from individual single-family homes with the exception of smaller owners who owned, I think we started the bill at 3 or 5 properties. It ended up being amended to anyone under 20 properties, I believe, is what the ultimate amendment came to. It could have been 10, but either way, that bill, even in its extended form of anything older than 20 years, and if you were exempt if you owned only 10 homes, or yeah, we'll say 10 homes, it got shelved last night. We pulled it, Assemblymember Bloom pulled it because we did not have the votes in the Housing Committee today. So that becomes a 2-year bill. The good thing is that it didn't go to the committee and die. It is still an active bill, or it'll sit dormant for a little while until next year, but it will allow us to continue the dialogue with the apartment association and everyone. So not the best news, but it's still alive.
Thanks for that update. Commissioners, any further comment? Nothing. No? So we'll move on from item 11 to item 12, staff comment, and I know we do have one this evening.
Yes, I wanted to mention that on March 28th, the commission voted to ask the city council if you could weigh in on the zone text amendment regarding a dwelling unit. I had mentioned to Chair Charity that that could either be made in person at a city council meeting, or staff could present that to the council. The chair thought that he could make it to a council meeting to present that in person. Unfortunately, his schedule precluded him from doing that, but it's now on the May 6th agenda for city council. So Chair Charities has indicated he's unavailable for that meeting, but the chair can appoint a representative to attend the meeting. And because it's on the agenda, in addition to making the request that you all have, that you all made, you would also ask just a procedural point, you would ask the city council to table the item and then ask the city council to allow a formal presentation on that ZTA before the council takes action on it. So if the commission wanted to, or excuse me, if the chair wanted to appoint a representative, if one was available for May 6th, you can do it that way.
And I know Commissioner Kerbers, you were pretty passionate about this. Are you
I have
available?
a couple questions. So there's no written document from this commission that went to the city council?
So, as I mentioned, there were two options in how to present the request, and so I gave those options to the chair. The staff could either have made that request on the commission's behalf, or a commission representative could go to the meeting in person and make the request during public comment. The chair chose the first option, to go in person to the council meeting.
And
so aren't staff required to provide council updates on what commissions and advisory boards do? This wouldn't have been a timely and relevant one to do so?
No, as I said, the chair indicated to me that he wanted to go in person to the city council meeting and make that request.
And honestly, I was a little confused. I thought I had to go, and that was the only way we could do it. But I just was working and I couldn't do it.
So no, I don't blame you at all. I'm just shocked that there are things that staff are required to do, like provide council updates on what the commission and advisory board activities are, and then there are things that, like this, that they choose not to do. When the commission's made it very clear what we would like.
I'd like a chance to speak if I could.
I need to address that verb. That is not true. It's not that we chose not to do it. I was given direction by the chair of this commission. I gave two options, and I was given direction, and I followed that direction. If the direction had been staff needs to make that request on behalf of the commission, that's what we would have done.
So when you ask for it to be tabled, that's simply so it could come back for discussion here. Is that correct?
The request is to, as I understand it, the request is to ask the council to allow a presentation on the zone text amendment before the council takes action on it. And because it's on the May 6th agenda, it would need to be tabled first.
It's coming up pretty soon. I feel like it would be, not in poor form, but if we show up the day of the hearing and have somebody make the request when everybody's prepared to present, it seems less likely that we'd be successful than if we gave advance notice. So unless there's a legal impediment to it for some reason, given that this was something that was passed, that's in our minutes, my preference, we could also do that, but I think that today or tomorrow somebody should email the entire council to let them know.
If you would like staff to do that, we are more than happy to do that as well. It's entirely up to the commission how this goes.
I think that's preferable.
If you don't mind, I would really like a chance to offer some comment because I have been working on this. And I apologize. I don't think that Ms. Regan and I are on the same page because I wasn't there at the meeting, and I did review the minutes. And I didn't come across with any indication that this was an item that the chair would be taking forward. And so I followed staff's protocol that we've established with the city clerk. But I would just want to share with you the timeline here is that the item was made on March 28th.
Council, so I'm not sure what he means by protocol, because this has not gone to city council. City council is unaware of this request.
So the request was made on March 28th. And you adopted your minutes on April 11th, and I sent the request to Yvonne Quarker, the city clerk, to forward that to the subcommittee of the council. The request came back, however, that the indication came back that the item was already on the next council meeting, and that there was a bit of an issue because having this request come forward to the subcommittee and having the item come to the council would put that on the same meeting date. And so there was an awkwardness. What this did was it allowed me and the city clerk, along with the city attorney, looped in with the city manager. So I'm working with the executive team in the city. What we'd like to do is we started to look at the purview of the commission and specifically at the housing policy item. And that came in 2005. And we started looking at the commentary behind that and the discussion from the council. And if you're willing to give me a moment to look further into that and work with the city attorney and the city clerk, we're coming up with a way to define that better. Because I think in 2005, that did come in with purpose. And I don't think that staff, as far as I can tell, staff hasn't defined that. The commission and the council haven't defined it either. And so what we'd like to do at this point is to come forward and define that. I do have to apologize that we weren't able to send this forward to the council subcommittee, but hopefully you'll appreciate the awkwardness that we were in, that the city clerk came back and informed us. It is true, you can come to the council meeting, and other commissions do that. And so what Ms. Regan is providing you with is that venue. Certainly you can communicate with your council members as well on this item.
Just so I'm clear, so some of the members of City Council, those who are on the subcommittee, are personally aware of the request?
No, they're not. So this email was
Sorry,
sent.
that was directed at Mr. Noonan, because
But
he's the
they're
one that
not
was
aware.
communicating with them.
Right, so I did follow through on our process, and I did send it to the clerk, but the clerk alerted me that there's the problem. What's problematic is that the item is on the council meeting coming up. And so in her opinion, it wasn't, and it wasn't just a conversation between me and her, this was a conversation between me and the executive team with the clerk, that the challenge is that the item is on the same, it's coming up on the same meeting date, and if the subcommittee were to direct this, that request to the council would be on the same meeting date as the item. And so the better approach would be for the commissioners to come to the meeting.
Okay.
Just to
So-
answer your question, Commissioner O'Keefe, the subcommittee's not aware. So back to your earlier question, yes, staff can transmit this request to the council before May 6th, so
And-
that it's immediately in front of them. And then if someone wants to be there on behalf of the commission at the meeting, that's fine too. I also wanted to just point out, so that the timeline is clear, this email to the city clerk was sent on Monday. So obviously the item had been on the agenda since the last draft. So the clerk's point was that it's too late now to go through the normal process of the subcommittee. And so we're saying the same thing. So essentially we're in the same boat that we are in. And so the solution, if the commission decides to, direct staff to send that request to the city council tomorrow. I can do that myself. I'm happy to do that. And then if a representative also wants to be at the May 6th meeting, that would work as well.
It would have to ask for it to be tabled. Is that correct?
They would make a public comment, essentially mirroring the request that the commission has made.
Thank you.
So my
I think our
preference would
initial,
be-
sorry.
My preference would be that both staff would communicate this desire from the commission to city council as a whole, and that we appoint someone to appear at that May 6th meeting. Mr. Noonan, I don't, this issue about it being awkward, to me is not relevant. I think city council can completely go, oh, we have this information from the commission that deals with housing issues in the city. They would like to be heard on this, so at this point in time, we're going to remand it or whatever back to the Rent Stabilization Commission, or not. They could say, we don't care to have your input, but we'd like to hear either way. So I don't find that there would be anything awkward in requesting this from council or their subcommittee. I think that we just make that request now on kind of a two-pronged approach, asking staff to make that presentation to council as quickly as they can in writing or email, and that if this commission can find someone who is available on the 6th, the 5th is my birthday, so I'll be out of town, to appear to say that we would like the opportunity, if council agrees, to have a presentation at the Rent Stabilization Commission before council moves forward with this.
And I'll just be frank, I'm not as well-versed verbally, and I don't have my head really wrapped around this particular issue to speak as knowledgeably about it as other commissioners. So I think somebody could do a better job than I could, is just the honest truth.
I personally don't know that I would want us to specifically say the word table it. I would prefer to communicate it as, on March, whatever, we passed this asking to weigh in. There was some crossed wires and it didn't get communicated to you until now, but we want to let you know that we feel like this is in our purview and would want to weigh in. Hope they'd table it, but I don't know that that's what we passed when we asked to weigh in, and there could be a lot of people that want it considered at that time. I wouldn't necessarily oppose it. I'm just saying I'm not sure I want to specifically say table, even though in effect at that point we would be asking for it if we're asking to weigh in.
Is that the preference for the written request as well? I mean, that's fine.
Not use the word table, that's mine, but
Well, why couldn't we ask in the written request for it to be tabled?
I mean, we're asking for exactly what we asked for, which is we want to have it come to our commission before they have it.
I think the city council would recognize that that's what they'd have to do if they wanted to do it.
I don't think we have to use the word table. We can just ask for exactly what we
Sounds
asked
good.
for.
yeah, so I'm sorry we had cross signals. We didn't communicate this earlier. However, at this point, we want to let you know that we want to weigh in. We think it's in our purview and so forth. And Commissioner Kerpes, did you want to be the one to speak in person?
Well, I probably don't think I'm the best person to speak in person because I don't recall I know my point of view and why I was advocating it to you all, but I don't know necessarily what parts of that the commission bought into and which parts of it are still my own. So I think it's better off. I will definitely be speaking with all 5 council members about what I think about this process. Which includes, I hope that it comes back to the commission. So I would not be the best speaker for it, and I don't even know if I can make it to that meeting.
Okay.
I'm not available.
Well, I think we're getting it through from staff, and I apologize for not being available either. I work a lot that day, and Mondays are just awful at a law firm.
If you could ask City Council to table their May 6th meeting to a date not after my birthday, I'd be happy to do that.
Well, great. Then we'll have staff transmit our request to City Council, and each of us individually. I know I have a good relationship with John Duran. We talked about the issue briefly, so I can at least bring it up to one of the council members. And Josh said he's going to bring it up as well. So, anything further, Commissioner? Okay.
So I had other points.
Okay, thank you, Peter.
Thank you. I appreciate it. So again, I'll repeat that in light of this, and I think the bigger picture here is for us to look at what it really means to have housing policy in the commission's purview. And I am talking with the city attorney and with the executive team on how we can best do that in a way that is very supportive. So if you'll just give me this moment to figure that out, I'll come back with an approach that I think will work, that will be for the best. Because as you can appreciate, housing policy can be a fairly broad term that spans across at least potentially two other commissions areas, the Human Services Commission perhaps, and certainly the Planning Commission. So we want to make sure that we can create something that defines a meaningful way that the commission can weigh in on that. I am going to look back at a little dig further into the 2005 process and what happened there. Because what we've seen so far is when we added that language in, the council at the time did ask staff to return in 90 days with further discussion. And I haven't had a chance to look at what that discussion was. Of course, I came on board in 2013, so a little before my time. The other aspect, it did come up again, and it did come up a couple years ago, the question of what does that mean? And we didn't pick that up and bring that back to council. So it wasn't any fault of ours, it just simply was that there was many things on our agenda, and it was one of those things that we didn't get to. So I think it's very important now, however, that we do it. And so allow me the moment. I wanted to take a moment and just address a couple of points that the commissioners had that came up in the last appeal. So staff at City Hall, we can't advise people on legal aspects, and we will refer people to CES, to the Center for Economic Survival, or we refer folks to an attorney to represent them. So we are very clear about that. We're gentle, we're courteous, but we just simply can't respectfully advise people on legal aspects in the code. So it sounded to me like was some of the conversation that perhaps was happening at City Hall. We do have some folks come in that are a little frustrated by that. But we do take our time, and we do try to support folks as best we can and point them to the right resources. Certainly, we have BetCetic that we share with folks, and that Ala Chasnik at BetCetic is available to take questions from tenants in the city, and then we have CES. We do include a conversation and some topic points on subtenants in our educational series on the building blocks, and I can talk to the staff that run that and make sure that we have enough information and that it's adequately broad to cover all information regarding tenants and subtenants. Those are my comments. Thank you.
Commissioners, anything further? Yes.
I think that's good that it's included in the building blocks, but a relatively small percent of people physically attend them, and I'm wondering if it's been in the issue of the fact that the ordinance applies to master tenants who rent out rooms or have roommates that aren't on the lease, if it's communicated in any of the mailers that go to everyone, and if it's not already, I'd suggest that maybe it should be.
We can do that. In fact, we can do that in the next newsletter.
Thank you.
Commissioners, anything further? I just want to say thank you, Ms. Regan. Thank you, Mr. Noonan, for helping us out there. And we'll get that request in. Thank you very much. We'll move on to adjournment. Our next meeting is May 9th, and this meeting is adjourned.